He said it again.
For the fourth time, we want discovery on a case that's not going to go.
Let me choose my words. I wanted discovery on the case that was scheduled for a preliminary examination at 12 o'clock today. Well, we don't know if it'll go, because what if the complainant just so happens to walk in? Rather than waiting last hour and we keep on doing this.
Okay, please don't talk over me.
I'm not going to talk over you, Judge.
He's still talking over me.
Well, you're cutting me off.
Yeah, he's the judge.
You stop. Understood?
No, I actually don't understand that, Judge.
Why don't you come down here and I'll make it clear to you. Come down. I'll see you at 12 o'clock.
I'm not coming at 12 o'clock, Judge.
Okay, don't come then and see what happens.
Okay, so do you want Attorney Davenport, who is the attorney on this case? Do you want to speak to him? Because if you're asking me,
why are you even talking to me if you're not on this case? I don't even want to talk to you then.
Well, you asked a question about me, Judge, so I started speaking.
You're talking to me if you're not involved in this case.
Well, I am involved. I'm co-counsel on this case, Judge, but just to be...
I want you to come down here at 12 o'clock today.
I won't be coming, but here's Attorney Davenport.
And I'll hold you in contempt of court.
And I'll go ahead and file a grievance.
Do it.
I will.
I don't appreciate any yelling. I feel like it's unprofessional. I feel like she was trying to express the fact that this...
And I asked her not to talk over me, Mr. Davenport. Just like you stopped when I started talking, I expect the same from her.
Just as this happens in other cases, we expect discovery in a timely fashion so we can represent our clients in the best way possible. So as these cases become moot points of discovery, we would like to be...
It sounds really high.
If the complaining witness does show up, we don't have to wait till the last minute. We can either hold the exam or not. We started off asking for discovery in court. We were told we have to submit a discovery order. We started submitting discovery orders. After we submitted discovery orders, we were told we have to keep in communication to remind prosecutors that we have to get our discovery as they're obligated to provide us with. After that, you told us if we were in communication, then we should file motions to compel. We keep trying to do and be proactive. And we're trying to explain this problem right now. But there's no reason
Mr. Davenport, if the witness was to show up, there's no way I would make you go forward on the case that you just received discovery on today. Period. Now, let me talk about what I don't appreciate. I don't appreciate being talked over. I don't appreciate when I'm trying to make something clear. Ms. Davenport indicates that she didn't understand. I told her to come down here. She told me what she's not going to do. I ordered her to do so. So understand that grievance process works both ways. I can file a grievance as well.
And so in this situation where she's trying to get the case dismissed before 12 o'clock because we wouldn't be holding it whether the complaining witness shows up or not, and we're trying to be efficient with our resources.
I'm not inclined to that. I'm not inclined to grant a dismissal when discovery was given to you, although it was not given to you timely. I'm not inclined to dismiss based on that.
What would be the future? What would be the remedy for future reference?
What future reference? What are you talking about?
So in any other case, in a situation where we submit a discovery order, keep in contact with the prosecutor, submit a motion to compel, and the discovery
case by case basis, sir. I can't tell you what I'm gonna do in the future.
Oh, okay.
I don't know how to comply.
I mean, so we just have to keep.
You're not gonna comply anyway, Ms. Davenport.
I'm sorry, Judge, I didn't hear you.
You told me you're not going to comply with the court's order. I ordered you to be here at 12 o'clock. You told me you're not doing it.
Judge, I can't come down there at 12 o'clock today. But when you see me on another hearing, or if you want me to come down on a different time, then we can definitely discuss it. In fact, I know that is this recorded? Because if this is recorded, then we both can use it in our grievance. But Judge, you asked me a question. I started answering. You cut me off, and then you said, when you start talking, I stop. I'm not a child. I'm not a puppet. I don't disrespect you, and I expect to be respected as well.
I expect you to respect this court.
I do respect this court, which is why when you ask a question, Judge, I stepped in to answer your questions.
I don't like being.
I don't like to talk over people either, Judge. It's just that when you ask me a question and then I'm answering it, when you're cutting me off, how do I know if I'm answering your question? When am I supposed to stop or not? If you want to speak, then I will be quiet so that you can speak. And then when you ask me a question, I'll answer your question. Oh, I'm sorry. You want to speak to Attorney Davenport?
Ultimately, Judge, in this
down,
situation, which was a similar situation as last week, and I understand it's unpredictable and we can't really determine what you'll do based off past action. But last week, when the complaining witness didn't show up and the discovery issue was moot on a different issue, I appeared in court physically. Now, that wasn't a requirement for the prosecution as they came in on Zoom, and I have no problem with that because it's an efficient use of resources. However, I don't agree that it's an efficient use of everybody's resources if we're not going to hold this exam to have us continue to come show up in person. We're doing all this back work trying to make sure we're prepared. So we prefer to appear on Zoom.
I don't have an issue with that.
Okay, thank you.
The prosecution is indicating that the witness is not going to appear.
Very well, Judge. Would you like us to appear at noon?
That's what time the exam is scheduled.
That's true.
You don't want you to address discovery issues in advance no more?
Won't be able to tell. Yeah, wait for the next case. Okay, so we will appear back on Zoom at noon for the dismissal. And I'll see you then, Judge.
A lot, Jillian.
Is there any other issues you'd like to take care of?
No.
Okay, we'll be back. Thank you.
Well, that was quite the shit show, wasn't it?
Manager?
Yes.
Good morning to you and your staff of Juvenile, E52026 on behalf of Justina Shabazz, Davenport, who is to my left. Defendant, should I thank you? If I may.
Yes.
So, Judge, I do understand that there was some conduct that happened in this courtroom yesterday by way of Zoom technology. I had the opportunity to view the YouTube recording. And on behalf of the Wayne County Criminal Defense Bar Association, of which Ms. Shabazz is a part of, let me extend my apologies for the behavior that was witnessed yesterday. And thank you for the grace, Judge, of letting us come forward to try to make it just a little bit better or a little bit less while not forgiving the conduct. I've had the opportunity to speak with Ms. Shabazz and several other attorneys in trying to resolve this issue, and one of them being Mr. Todd Perkins. I take no pleasure in standing here, Judge. And I think I've explained to Ms. Shabazz the error in what happened in the way things happen. So if there's an error issue that you might have with any judge or any person, you can always go and try to talk it out, as we're all human beings, right? We're just human. That's all we are. And understanding Ms. Shabazz is a younger attorney, and we are learning. But I did explain and say this is one of the reasons why they do not want us to use Zoom technology. That is going to be a poster child for why Zoom technology should not be allowed in the courtroom. I had to go testify in front of the Supreme Court or give comments on using Zoom technology. Sincerely, Judge, sincerely, I really do apologize, because this is not, for me to come down here from Ann Arbor, where I was in court, this is how important this court is to me. This is not how we treat this court. I understand we can have opposite, we may not agree on anything. We don't have to agree, right? But we're not going to be disagreeable just to be disagreeable. So we are sincerely, and she can tell you, but I just felt the need, because I am the president of that organization and which Ms. Shabazz is part of, that is not, we are going to treat anybody and nothing about courtroom 234. Is this 234? 234
I love this lady.
gives anyone the right. I understand being frustrated, and she's a mother, a lot of things going on, I'm sure, right? But
The two boys in the background.
has been counseled. She will continue to be counseled, because we're really not happy. But thank you for the grace, Judge, and I will let Ms. Shabazz speak to this court. And all I can say is, sincerely, I am sorry. Because as I explained to Ms. Shabazz, yesterday, you got a dismissal. You wanted a dismissal on something dealing with discovery. That would not have been the proper remedy. So let's say we're somewhere like in Novi or Garden City or Brooks Point, right? What would have happened if that was an issue? We're going to adjourn this preliminary exam and put a witness detainer out. We are client focused and not ourselves focused. It's about the client. And I'm sure Ms. Shabazz understands that at this time. And I will let her talk to you, Judge.
Before she does, how do you follow that? I think the judge is sitting there like, yeah, I'm just going to agree with this one because she's terrifying in the best way. That lady right there is so awesome. Like, holy shit. But this young one over here, the lady that's in trouble, the one with the mask on there. Look at her body language. She's just sitting there, not even looking at the judge. She's got enough cheek for another arse. And her boss, you can tell. This is her boss cooled down in court. She would have torn her a new arsehole inside in their office. I can imagine. Oh my God, I love this woman. She's awesome. Awesome.
Mr. Vance.
Thank you.
I didn't really understand what you're saying.
Can you hear me good? Can you hear me?
Barely.
You want to blow my nose? Can you hear me good?
Yes.
Just want to offer an apology to the court for any disrespect that the court may have received, especially yourself as a judge. I meant no disrespect, and so I do want to offer an apology.
What an arrogant little shit she is. I'm sorry now, man. The boss is coming in hot here from behind. If she doesn't clip her around the ear, I don't know who will. I want to say sorry. It's like when you get caught for something as a kid and you're like, say sorry, like, sorry. That's basically what she just did. Like, she wouldn't even take down the mask. I get it, COVID, all that bollocks. Take down the fucking mask. There's nobody standing around you. You have bulletproof glass in front of you. What an arsehole.
So let me say this. In my 17 years on the bench, I've never been disrespected like that before, ever. Nor have I ever witnessed any disrespect like that coming from an attorney. I see stuff like that from the defendant time and time, but never from an attorney. I expect more from an attorney. The only reason that this court didn't hold you in contempt of court at that point in time, because you've appeared before this court on many occasions. I don't think you've ever had an issue. You may have had disagreements, but you've never had an issue to rise to that level. We're human, like Mr. Yalla says, and we have bad days, have good days. Some days are worse than others. That doesn't excuse your conduct. I have every right to hold you in contempt of court. And if it was not for Mr. Yalla, you would be marching back to the jail, Wayne County Jail right now for 3 days. Courtroom. forced to hold you in contempt of court and to report you to the State Bar of Michigan.
She could have lost
I
everything.
don't necessarily like to do that to young attorneys, particularly young Black attorneys. I like to give some deference to us because I've been where you are, but never would I ever phantom to behave in the manner that you did. It's very disappointing, it's insulting, it was embarrassing.
Yep.
Court is willing to give you a pass on this time. If this ever happens
Look at the
again,
boss.
Ms. Diallo's not going to say, and I have the utmost respect for Ms. Diallo, for Mr. Perkins, for Mr. Clemens, for Mr. Pope, Gabby Silver, Otis Culpepper, Cornelius Pitts, and other attorneys with way lower P numbers than you have. We've been around a long time, know the proper respect that you should show this court and any court. Your behavior was inexcusable. The more I thought about it, the angrier I got. So I encourage you to follow the lead of Ms. Diallo, who's a very fine attorney, well respected. You're going to get there one day, but you're not going to get there if you continue to behave like you did.
Her attitude still, man.
This court is not going to hold you in contempt of court. Although I find their behavior was contemptuous. Not going to do that this time. If it happens, if you make a mistake about it, nobody's going to say it.
Judge, and once again, thank you for the grace that you have shown. Sometimes I don't think we understand. Like you said, sometimes we have good days, sometimes we have bad days, right? And I know I'm extra. Well, you know I know I'm extra, right? But
I love this woman. She is, lads and lassies, is she not just awesome? I'm extra. I love her.
Always respect.
Right. I mean, something like that. And we get frustrated at times. I understand, but Ms. Shabazz really is apologetic, and I'm going to try to. I'm going to continue to mentor in hopes that, and it's not hope, she'll get there. But it's just as we grow. These are growing pains, and I would have to chalk it up to being a new mother and all that other stuff. There are a lot of things that go on, but thank you. And as you see, we take this very seriously, right? Extremely seriously. Because I don't feel good about this right now. I feel a certain kind of way.
I didn't feel good about it either. And when you first reached out to me, first thing I uttered to you was talking down to me because I was going to hold her to the court. Because I cannot let that kind of behavior slide in any form of fashion from anyone.
Thank you.
Thank you.
Are we concluded, Judge?
Yes.
Thank you. All right.
Judge, I'm sorry. Are we going to address that one issue?
Counsel, I didn't address you.
Good afternoon, everybody. The Irish Demon here, back with another video. Now, we see some pretty crazy stuff happen in court, but in this one, we got a guy who's acting really cagey and a lawyer that tries to hide his presence. You see, he's in a court that he's not meant to be in. And in the small claims court, depending on the jurisdiction, generally speaking, you can't have legal representation there with you. And that is the case in this one. Now, there's a couple of things I want you to look at. Obviously, there's the explosive incident between the lawyer and the judge, but then there's also the fact of whether or not the lawyer actually left the room. I want you to keep an eye on Mr. Potter's face and tell me if it looks like somebody's in the room or not. Now, I obviously don't know, but I'd like to hear your thoughts down below. Let's get stuck straight in.
Was there an attorney? Was there an attorney on this?
I obtained one, yes.
Well, I don't. Who was that?
I have obtained an attorney, and I am going to file a motion to set aside the judgment and move it to circuit court or district court.
There's already a judgment.
Yes.
Was there an attorney? Did you guys have, you guys were talking in the breakout room today?
No, I just learned in the breakout room that he had an attorney, and I want to know why the attorney is here. Because as you
Where's
stated,
the attorney? Where's the
there is
attorney?
Right here.
Who is it?
Right here, Your Honor, Kevin Miller.
Together if they're in the same space.
It's Kevin Miller.
I can't see you. You need to move closer to this gentleman. Who is that?
My name
Slide
is
over. I
Kevin
can't see
Miller.
you. Get closer. Mr. Miller,
Yes,
why
Your Honor.
are you involved in this matter?
Because he wants an attorney to represent him at this point. The judgment is flawed and it should be set aside.
First of all, you're not even supposed to be involved in the mediation.
There was no
can't- you
mediation.
can't-
Your Honor, you yourself stated that there's a judgment entered. How can you mediate if there's a judgment?
What did you guys do today?
He was put into a breakout room and sent to a mediator.
that was an error.
Left the breakout room and let me know that it's
Fran,
set for discovery, and then
Fran.
I put them all in
Yes,
there by
sir.
mistake, Your Honor.
Fran, I want you to tell me what happened, because I'm not getting a straight answer.
You're getting a straight answer, Your Honor, and I resent that. I'm telling you exactly what happened.
Counsel, I didn't address you.
Yes, you did.
I'm addressing my
When you say
media.
that you're not getting a straight answer from what I told you, you are addressing me.
I asked you how it is
I told you
that you were
exactly
with the
what
mediator.
happened, Your Honor. We went into a breakout room with the mediator. You yourself said, Your Honor, that there is a judgment. How can you mediate if there's already a judgment? The mediator was also confused and wanted to talk to the clerk.
Okay. Go ahead, Katrina.
I'm sure that Mr. Miller knows that I have to manage the breakout rooms. And that's what I've been doing for a couple of years since we've been on Zoom. So I failed to notice that this was set for discovery today. And I did place the parties in the breakout room with the mediator, then exited the breakout room and informed me that this was set for discovery. I left the parties in the breakout room because they needed to conduct discovery.
Okay.
Judge Bullitt, this is Fran.
What's up, Fran?
I just was going to say that we didn't actually conduct any mediation. As I began to try to identify the parties and ask if they had been before me previously, and they said yes. I will note that Mr. Miller failed to make known his presence until I heard him speak, and I asked if there was somebody else in the room. I don't believe that that was very appropriate, Mr. Miller. But nonetheless, we did not conduct any mediation. I came back when I realized that it was a discovery based upon the docket, and so there was no mediation that took place. And Katrina did tell me that it was sent in error.
Counsel, you don't have the right to be involved in the process at this point.
We tried to file this to be removed and we were told we couldn't do it yet.
Counsel, then if no removal order was signed, you don't have the right to appear on this. Counsel, are you going to tell me that you don't know that attorneys are not allowed to appear in small claims cases?
I certainly know that, Your Honor, but when I file a petition to have it removed, I certainly don't expect the clerk to tell me I'm not allowed to do that. And that's
And when did you
happened
file
yesterday.
this petition? When did you file it?
I tried to file it yesterday and the clerk wouldn't accept the pleadings.
Yeah, because there's a judgment.
Doesn't matter, you can still file a motion to have it set aside if the judgment's improper.
And why is the judgment improper?
First of all, the judgment.
You know what? I'm not even going to entertain that. I'm not even going to entertain that because you don't have the right to be here. So
Well, you didn't have the right to
this
enter
is
the
a
judgment, you didn't
discovery.
either, but you did.
this is a discovery I'm not even going to entertain it. So I guess, counsel, I guess at this point, I don't want you saying anything.
I'm not going to say a word.
Okay.
Just tell myself out.
Okay. Mr. Potter.
Yes, sir.
You are supposed to be producing for Miss Smith your social security number, your bank account and credit union numbers, statements for savings and checking from bank accounts and credit union accounts, titles to all vehicles, titles to all real estate. Do you have that information?
Not under LLC, she can't get all that.
Not what?
Under an LLC, we're LLC. So, I mean, technically, they can only go after what's under the company name, right? Not personally. And the reason this judgment was set is because I made a mistake.
I don't think I heard you object on that grounds at any point. You were here in January, and I think you were here in March.
I made it to every one except for the last one, which you put in a judgment because I made a mistake and came on the wrong day. Because I wouldn't have missed it.
Okay. Well, I don't think you objected at any point. So judgments against, well, it says Potter's Concrete, doing business as Anthony Potter. Or maybe it's vice versa. So I think you're in the mix. So you haven't produced any of that for Ms. Smith?
No, I don't have that information. My wife does. Because she is the actual agent for the LLC.
Did he ever submit an evidence pack?
No, he did not.
I didn't think so.
Nor did he appear on May the 10th.
And that was accidental. I did call in, but it was too late. The judgment was already entered.
Then you had 21 days.
Did you file a motion to set aside the judgment at that time? In
No,
May
we tried yesterday to do
or
that.
July?
I'm
You're too late. It's not even, you're too late.
Yes.
Now look, you're too late. So,
Well, shouldn't even have won the case in the first place. You said you should have dismissed it, and that's what you said last time. And I missed the court, so she automatically won because I didn't show up, and that was not my intention, I swear, Your Honor.
Whether it was your intention or not, you still didn't show up for court. So if a decision was made in your absence, that's on you.
did we try to call him?
I don't have any idea, Judge.
Yeah.
I
I wonder if
Are
we
there
might
numbers in the file?
have even tried to call him.
No. 'Cause
I don't know.
I have one phone number. I have one cell.
I don't know. Sometimes I will call, sometimes I won't. It just depends on,
I didn't get a call.
it depends on several factors. If I have somebody who's consistent in showing up and they don't show up, sometimes, or if I think we're having trouble with Zoom or whatever, sometimes I'll make a phone call. But you didn't, you didn't file a motion. If you didn't file a motion timely, so you need to produce these. You need to produce what she's asking for. And if you don't do it today, you're risking her asking for a show cause hearing, and you're risking being held in contempt of court. And I'm sure your lawyer, even though I told him not to say anything, he probably could have told you that, or probably would tell you that. When are you going to produce this information?
Well, I'm not going to do it over Zoom. And I honestly I'm trying to work stuff out with my insurance company too, but it's not very fast, so.
Well, you know what? All of that, look, the case has been going on since last fall, hasn't it?
Yeah, oh, believe me, I know. I've been on Zoom and I've got a lot of hours into this case, and then for it just to get thrown out.
Okay, so
I was there every time.
Let me say, no, I think she.
Yes, I was there every time except for the last time, and that's when you gave her the judgment. Because I wasn't there, and I called in later that day.
Well, if my memory serves me correctly, there seemed to have been some issues about you guys hooking up to do the whatever you were going to do to fix it. There was an issue about that too.
No, I went over to her house. I agreed to redo it. She decided she was just going to take me to court and sue me.
He didn't provide.
No, I'm not talking about. Yes, of course I have it. What about it?
He was given ample enough time to come and appear before the judgment. Before the judgment on May 10th, before you even issue that. So, this has been going on forever, and I'm just, if he doesn't want to comply, Judge Marble, I'm asking you to issue a bench warrant for his arrest if he can't supply me with
ma'am, that's a little bit premature. He's here. I'm giving him an opportunity. Are you at your office now, Mr. Potter?
No, sir.
Well, I see a bunch of filing cabinets,
It's
behind
not my
you.
office, sir.
Well, I don't know. Where are you?
In Davison.
Well, what? Who owns the space where you're sitting in right now?
An attorney.
An attorney, or the attorney sitting next to you that's not supposed to be here?
No, it's a firm. I guess you'd call it Davison Legal Associates.
Okay. All right. Well, look, Mr. Potter.
Yes, sir.
All right. This is what I'm going to do, Mr. Potter.
Yes, sir.
I'm adjourning this to the 23rd. You're to bring the things that are listed on subpoena to the courthouse, and Ms. Smith, we're going to set this for Tuesday, August 23rd, a week from today. We're going to set this for 9:30.
So is this going to be via Zoom?
No, I think I'm gonna.
They both need to appear in person.
Yeah, you guys got to be here in person so you can get a copy of this information that he's going to bring. Now, if he doesn't bring the information, then I guess, he's going to have to. If he doesn't do it, he's subject to a show cause hearing. And if he doesn't do it, then a bench warrant can be issued. So.
This is really putting me out. I am physically I've not got to get an amigo to come here.
You're going to have to do what?
An amigo.
Have you got a wheelchair?
I don't have a wheelchair. I have an amigo. and my grandkids have to break that down for me in order for me to come to the courthouse.
Okay, well, if you have to pay somebody to get you transported down here, then you give me the billing for that, and I will consider adding that to the judgment. I mean, Mr. Potter could email this information to you, but he's insisting on showing up in person. You do have email, right?
Yes, I do.
And Mr. Potter, you got email too, right?
Yeah, pottersconcrete@gmail.com.
Yeah, okay. I mean, you could easily email it. So, I don't know.
Just a quick break, have a look at the two gentlemen at the bottom of the screen. Now, the guy with the little beard also has a massive screaming match with the judge, and it's absolutely epic, and that will be linked at some point down below. I'm waiting for that video to be monetized. Unfortunately, YouTube have been smashing me with demonetization lately, so if you want to make sure and support this channel, hit that like button and comment and subscribe. Consider becoming a member, Patreon, and grabbing some special edition Irish Demon merch for the upcoming fight in Kentucky.
You know what?
If she's got to come down... If she's got to pay somebody to bring her down here and has to have special accommodations and pay somebody for that, we'll just add that on. It's not a problem.
Okay, that's what I'll do.
You need to bring receipts and proof of you paying somebody to do that.
No, I got my grandkids to do that. But but that's just, I'm trying to get these kids in school. I'm their guy.
Well, ma'am,
I was hoping everything would be completed today.
Well, ma'am, it's not going to be.
I see. So the August the 23rd at 9:30.
Mr. Potter, you were served with the subpoena, right? Now, again, ma'am.
Yes.
If you want to give him your email address, and if he emails this stuff to you, before, well, you would need it by the end of the week. Or by the weekend. If he wants to do that.
So what if all the information I'm requesting is not sent via email?
Then I guess we all see each other on next Tuesday.
Yeah. Yeah, I'd rather do that.
Well, ma'am, if he could email everything to you and save everybody a trip, then everything will be good. But if not, we'll see everybody on Tuesday.
So what if the email have all the items that I'm requesting? That's my question.
Then we'll see you on Tuesday.
Okay. I'm
just telling him, if he fully complies with Mr. Potter, if you fully comply with the subpoena by email, you could save everybody a trip down here. Otherwise, we'll see you on Tuesday. Okay, let me move on here.
Now that was quite an interesting case. I don't know what the background of it is, but this guy felt the need to hire an attorney that wasn't supposed to be there in the first place, evidently, rather than just pay the lady the $1,000 or whatever it is that he owed. Now it seems like the lady is disabled and it's quite difficult for her to get to the courthouse, and it appears that this guy's trying to make it as difficult as possible. Now let's turn our attentions to the attorney. Should he have been in the room? No, he shouldn't have. Did he know he shouldn't have been in the room? I think maybe he did. Allegedly, don't sue me. Because it was obvious from the start that he was trying to hide off screen. And then when the mediator came on, she said that he didn't make himself known until later on in the conversation. He also seemed to have a bit of pushback to the idea that he wasn't supposed to be there. Now, what do you think about a situation where a lawyer talks to a judge like this? Do you think it's appropriate? Do you think it's the right way to do it? Maybe it's not. Let me know what you think down below. Anyway, folks, thank you so much for joining me. We'll catch you in the next one. There's a few people in this world that you definitely shouldn't mess with. One of them is Judge Alex Manning, and this lawyer decided to mess with her. Now, I don't know if he was telling Porky Pies about what was happening, but he did weave a bit of a yarn, and I don't think Judge Manning bought it. He started to get a little bit cheeky. In fact, to be honest, he had enough cheek for another arse, and the judge was having none of it. And yeah, she's going to be bringing him in for a contempt hearing.
Go ahead, Mr. Walls, before we're going to bring out a next case, but go ahead. You weren't here this morning. You're on mute, Mr. Walls.
Your Honor.
Morning.
Forward email communication. I have been in communication with.
Okay, hold on a second. Can't hear. Hold on. All right, go ahead.
Yes, I've been in communication with Ms. Watts and Attorney McCullough. It was my understanding that it was made clear I wasn't going to be available today, and that we were looking to schedule another date. I haven't received that date as of yet. I think it was a miscommunication to where I was under the impression in lieu of filing a conflict letter. Ms. Watts sent the email requesting available dates along with Mr. McCullough. So I think that's where the disconnect was at. And actually right now I'm on bed rest. The case that I had in South Carolina today, I had to have that continue. Either way, I wasn't going to be in this court today. But I am on bed rest. My doctor is supposed to be sitting upright at the moment. And I have my doctor's excuse. So I think it was just miscommunication on, I think, my part. I work in a lot of different jurisdictions. And procedurally, every jurisdiction does things differently. So I was under the impression that I was excused once I made it known that I had a conflict, and I was included in the email communication with Mr. McCullough.
Okay, so Mr. McCullough can't excuse anybody, one, but there's, under 4.2, entrance of appearance and pleadings, and your appearance, duties, withdrawals, attend, and remain, you got 4.2 and 411. There are rules under the Georgia Superior Court rules that you have to do at entry of appearance. You have to file a conflict. There's never a waiver of conflict. I didn't excuse you. One, if you're on bed rest, I get it, but you've got to communicate. I told you to put your contact information on the State Bar website. It is not there. We told you to correct your email information on your pleadings because it is not there. So your email is incorrect. And the final thing, I was advised by Ms. Watts that you hung up on her. Stop. Never.
You want me to ask
don't stop, Mr. Walls. She said you hung up on her, so don't call Ms. Watson. Okay, hold on. Rule 1, don't interrupt me. Do not interrupt me. If you were accidentally disconnected or what have you, doesn't matter. You do not speak with Ms. Watts like you did. When you're speaking to Ms. Watts or anybody in my office, you're speaking to me. So unless you want to talk to me like you talk to them, put yourself in check. Smile. It's not funny. I'm this close to holding you in contempt, Mr. Walls. This close. It is not that hard for you to put your contact information, which is required by the rules that you put your contact information on the State Bar website. I told you. Ms. Watts told you. I checked it just a few minutes ago. It's still not on there. And your email on your pleadings that you type is wrong. Your email that you type on your own pleadings is wrong. Your website doesn't. There's no way to contact you. Well, it looks like you're a little bit put off talking to me, but in the meantime, your client's been here waiting on you to appear. And they said if you had a conflict, you had to file something and give some more dates. I saw the interactions, but you didn't respond with any dates. Well, I am so sorry. I am taking up your time, Mr. Walls.
I'm listening to you. I just don't appreciate your tone.
Mr. Walls, do you think I appreciate you not showing up in front of me when you've been notified twice to come here? You don't put your own information. I'm muting you. You don't put your own correct contact information. I told you personally on the phone, correct your information on the State Bar. There's never a waiver of a conflict letter. And then you didn't respond to them, giving them dates where you were actually going to be available. Who does this hurt? Your client. And I hate that you don't appreciate the tone, but I don't appreciate you showing a lack of respect for this court. You may not respect me. You don't know me. You may not like me personally, but you'll respect the decorum of the court and the fact that I'm in charge here today. This is the people's courtroom, and you don't talk to the people like this.
So I guess after being told off by the judge at this point, he realizes, you know what, I should probably behave myself and act with a bit more decorum. No, he has a bit of a chuckle to himself, and the judge does not like it. She didn't like it so much that she unliked stuff that she liked before.
But it's funny. So we're going to set this up for a contempt hearing too. What date are you available? Yep, that's what we're going to do. We're going to see about a contempt hearing. Ms. Watts, give me some dates. It could be on the same day we bring him back for his prelim. I've had an officer here 2 times, Mr. Walls. 2 times. And these officers are busy. As you can see, yesterday they responded to. So we take these officers off the street, make them sit in this courtroom and wait. Who's the officer on this case? What date are you available, Sergeant? As long as it's not a Monday or a Tuesday. Miss Watts?
May 11th, next Thursday.
Next Thursday, Mr. Walls. Think you can make it? You're on mute. I muted you because once again you were talking over me.
May 11th works for me, Your Honor.
I didn't even hear what you said. What did you say again?
I said May 11th works for me, Your Honor.
All right, Ms. Watts, what time?
9 a.m., Judge.
All right, we'll also put that on for the hearing on civil contempt. I'll send you the wording for that language for the civil contempt hearing. We'll hear you on contempt then, Mr. Walls. Make sure, once again, I'm advising you for the final time, contact the State Bar and put your contact information on the State Bar website. It's required that it be there. Number 2, check your pleadings because you type out your email completely wrong. Your contact information is not correct in Fulton County, in Odyssey, and Georgia e-file. You need to correct that yesterday.
Yes, Your Honor. I'll look for the notice.
Well, you're going to have to explain it to your officer. So, I mean, your own client, why you can't be here. So, would you like to stay on and talk to him after this hearing and explain to him why you're not here, why we're not going forward? Because it's not really my job to do that.
Well, he's been notified through his sister that I had a conflict on that date. So it was
no, sir. There's no conflict filed. There's no conflict filed in this case. So you can tell people all day long, but there is not a conflict that is filed. This is all I have to go by. The last thing you filed, once again, was your motions. And once again, it had the wrong email address on there.
Like I said, I already explained to my client. So, no, I declined to explain to him. I could set up a visit with him to go in more detail. Otherwise, I'll see him on the 11th.
See you on the 11th at 9 a.m. All right, let's go. We got, this is Mr. Huff. Raise your right hand. Detective, do you swear? Thank you, officer. I'll see you then.
So there we have it, folks. A pretty quick one, but Judge Manning, as you well know, does not mess around, and this guy got telt. So we'll be back for sure for that hearing. Hopefully it'll be live here on the YouTubes. Anyway, folks, if you did enjoy the video, make sure and hit that like button, comment, subscribe, and all that good stuff. And we'll catch you next time. Sláinte.
Evidence or anything like that, Judge.
Counsel, what do you want to give me? What do you want to give me?
I don't want to give you anything.
What
because
do you want to give me? No, Judge, counsel, if you're going to say I'm being unfair, what do you want to give me?
Judge, I want to tell you that I don't believe you should be considering anything that will occur after this.
What you represented to this court, and I realize you're advocating for your client.
Guys, I promise this is the last one for today. This one gets absolutely lit. This particular lawyer starts to argue with the judge, and I can kind of see where he's coming from, but the judge is having absolutely none of it. Anyway, folks, it's been a bloody long day. Thank you so much for joining me. I probably won't catch up with you at the end, but I'll see you in the next one. Sláinte.
District Court. 14th District Court, State of Michigan.
County of Washington. Now in session. Judge Jay Cedric Simpson.
The Honorable Judge Jay Cedric Simpson preside.
Okay, it's been a long day. I don't know what happened. Don't even look at me. Just kind of lost me. All right. Let's see here. We're all on. All right. Court does call the case of the people of the state of Michigan versus John Torres.
Good afternoon, Your Honor. Patricia Reiser on behalf of the people.
Good afternoon, Judge Joshua Van Loan on behalf of Mr. Torres, who's present in your courtroom.
Can you state your name, sir?
John Torres.
All right. This is the date of the adjourned sentencing date. There was statements given by the mothers of the two young ladies to the court. They asked the court to look at additional information, which the 911 the recordings of 911 were sent to the court. The court had reviewed them. Was there anything else from either side before the court goes into its decision? Anything from the people?
No, thank you, Your Honor.
Anything from the defense?
No, Judge, you've given us ample time. Thank you.
Let me just say that, and I guess there isn't an easy way for me to say this. And I guess, I don't know, I know the mothers gave their statements at the last hearing. I don't know, was there anything additional you wanted to tell the court? No, from neither, okay. There isn't an easy way for the court to say this, except for to say that, well, first of all, and I'll give everyone another opportunity to speak after I say what I'm going to say and what the court looks at, what the court has at least surmised. The defense's position is that certainly the defendant ought to be sentenced on the charge that he pled to. Much of that, frankly, I guess bears on the concept, or at least what has been said, that the defendant, Mr. Torres, was not in a position to see the accident. And that he was someplace else, which led to the plea. And again, it's not the court's province to get involved in what the particulars of the charge are, but to try to do its best to mete out a just sentence. Part of the reason also that the court had made a determination to at least hear the 911 tapes. I have a copy of the police report as well as Mr. Torres' statements. Was because I was going, and I said to the parents that there may not be anything that the court could do, but you were going to be heard by this court. And in doing that, some things, as I saw them, were a bit disturbing to me. And, you know, I'm not in, nor should I be in a position necessarily to do some investigation to try to figure out what transpired entirely. But ultimately the issue became, and I will make no bones about it, that if this court believed, despite the charges, that the defendant was indeed basically present when the vehicle went off the road and the accident occurred, that changes the court's perspective on what would be a proper sentence in this case. So initially, in listening to the 911 calls, particularly there were a few other calls, but I listened to Mr. Torres' call to 911. And that initially caused me some concern about whether or not the defendant saw this accident. And here's why. And again, I will give an opportunity to respond, but Mr. Torres initially contacts 911, and what was said to the court by Mr. Torres and what he had maintained to probation is that he didn't see this accident. I'm having a very difficult time believing that. And let me explain my reasons why. Defense counsel, I think, properly stated before that that Mr. Torres had called from someplace else. Mr. Torres contacts 911, and it's an odd call because of the way that I think the dispatcher was responding to Mr. Torres. But one of the things that was said is Mr. Torres put himself at First Street off of Superior. The dispatcher says that's not where we have you. Put a pin in that because that becomes important in the court's mind. At some point, Mr. Torres then says, I'm at First Street. He's then headed back to the location of the initial contact between the vehicles. Okay. All of that being said, I then review the police report and Mr. Torres' statements. And if everyone can recall, one of the things that the court was looking at was, did Mr. Torres chase these individuals and cause this accident? One of the things that was said in counter to that is that he's not near the accident, doesn't see the accident. Again, I'm having a difficult time believing that. And part of the reason I'm having a difficult time believing that is because there is an EMU security camera that's referred to in the police report that has these vehicles traveling down Huron River Drive, both at a high rate of speed, because Mr. Torres is in an Equinox, I do believe, and there's a truck. At some point, they get to the corner of Huron River Drive in Superior. According to Mr. Torres, it is a red light. The truck stops. He stops at some point. The truck continues through the red light. Mr. Torres indicates from the report, at least as I read it, that he then turns on a green light. Now, how that certainly all could happen. Bottom line is that they're then, Mr. Torres indicates in the police report that at some point on Superior, he disengages from, as he puts, following the vehicle. It's best the court's able to determine the distance from that corner of Superior where the turn is made to the railroad tracks. It's approximately 1,000 feet. Mr. Torres is then, if he is correct, and he is saying where he is to the dispatcher, this is where we take the pen out of that he's at first, but the dispatcher is saying, that's not where we have you. Mr. Torres is further up that road. But even if I give the defendant the benefit of the doubt that as far as he went was first, the railroad tracks are approximately 100 feet from that location. It is a clear shot from that location to see those railroad tracks and that intersection. It is not as though there is a crest. It is as though there is something that from first would obstruct one's view. The other thing that was specifically asked of Mr. Torres is he made it very clear that he did not go over the railroad tracks, but the additional thing that was asked is whether or not he crossed a bridge. Mr. Torres says he did not cross a bridge. That can't be true. Because as you're going up Superior, to get to first, you have to cross the bridge. Moreover, when Mr. Torres is later questioned and talking to the dispatcher, he had to not only cross that bridge once, he had to cross it twice because he had to go over the bridge and he had to come back to get to the location where it occurred.
Can I say something, Your Honor?
In a moment.
No.
No.
Moreover, when you listen to the other 911 calls that are called in, two vehicles that are traveling to the south, so they're traveling the opposite direction from the Getty's roundabout. They see the vehicle go in off, well, basically off the railroad tracks and have the accident. From really, and honestly, I mean, I don't know exactly where they are, but from putting again the defendant where he says he is, they are at a much further distance from those tracks than would be Mr. Torres. He's much further, let me preface this by saying, through the other hearings, it was stated to the court that he is nowhere near the tracks and that he is further from the tracks where this occurred. That can't be true and everything else be true. It just can't be. He is within 100 feet, really between 80 to 100 feet of that intersection when that vehicle goes off the road. Certainly, and it also is perplexing from the court standpoint. I thought I understood it initially. When Mr. Torres is telling the dispatcher that he has the license plate of the other vehicle, one is thinking, or at least I was thinking, that he is getting that license plate by following the vehicle. That's not the case. he actually had the license plate of the vehicle prior to it turning onto Superior. Hence, realistically, there is no reason whatsoever for him to have continued. There is no reason whatsoever for him to have continued up Superior behind that truck. Now, if somebody, and counsel, I will give you an opportunity to address the court on that. And like I said, I'm not here, and I explained to Mom, it's not my province regarding the charge. My province is to mete out the sentence with what's in front of me. And again, I will give an opportunity for a response, but I can tell you where the court is at this point. The court at this point is of the opinion, and that Mr. Torres saw this happen. When he talks about the kicking up of dust and other things, the only place in that area that's going to happen is basically at those tracks. It's not going to happen on the turn off of here on River Drive onto Superior. You're not paid. And, you know, and I'll just say it. When I look at all of this, I'm having a hard time believing that he's telling me the truth about this. Ms. Weidling, can you just put that GPS up? That overhead.
Can I say something?
I'll let you, if your counsel believes that should speak, then I will let you speak, but
Are you ready?
I'm ready. Can you blow that up, or you're locked?
Do you need it closer?
Yeah, I just need it closer to the. That's good. Right. Yep, right there. At the very bottom of the screen, you're going to see the turn from Huron River Drive onto Superior. Up top of the screen, sir, you will not disrupt these proceedings. I do not want to kick you out, but you are not going to disrupt these proceedings. Up at the top of the screen, you'll see the railroad tracks. And if you look at, I think the first, if you look down from the railroad tracks off of Superior, that first street coming off, which would be, as you're looking at the screen to the left, that's First Street. From there, you can see that there is a clear shot to that intersection with the railroad tracks. If Mr. Torres is there, he has a clear shot to that whole area. When you also look at it just in terms of his timing of the calls, the other calls that are coming in, he can't not be in that area and see what happens, because the other calls come in shortly thereafter, and they're traveling north from the Gettys area, traveling southbound on Superior. They see it. So again, I'm not here, you know, I don't. I'm not here to worry about what's charged, what's not charged. I have to mete out the best sentence I can with what I have. And I will let you know, and counsel, I will give you an opportunity if you want to somehow or another speak with your client prior to the court imposing sentence. But I do believe that jail time is appropriate given what I see. I can't, in giving that, I can't bring back these young ladies. And I told the parents, I can't do that. But I certainly can do the best that I can to make sure something occurs. If I believed that Mr. Torres was not present, that it was as it was portrayed to this court, a circumstance where he could not have seen it, that he would have been so far down on Superior that he wouldn't have seen the railroad tracks, then that's where I would land. And I would have no problem landing with that and justifying it. I can't, based upon his own statements, justify that as being true. He had to see it. He's telling me he's 2 to 3 cars behind them, that he's following them, and that he's at first, and it's a clear shot to those railroad tracks. If somebody wants to tell me how I can come to a different conclusion, then please tell me that. But I can take into account in terms of sentencing whether or not a defendant is being truthful with the court in terms of what they're saying. And I will be blunt. I'm just a plain talker. I don't believe that he is. Counsel, if prior to your, Mr. Torres is, I don't know that you can see him or not. He really wants to make a statement. I will arrange, counsel. I know you don't want him to. If you want, because since you're not here, if you want to talk to him, I will arrange to get him on a Zoom and get you guys into a breakout room so you can talk.
No, Judge, that's fine. I'm ready to make a comment when you're ready to hear it. I don't need.
Oh, go ahead. Sir.
Judge, with all due respect, this is wildly inappropriate. For you to be doing an investigation on your own, for you to be pulling up...
Counsel.
Go ahead, Judge. You're the boss.
Counsel,
Yes, Judge.
Stop a moment. I think I acknowledged that. I'm not here doing an investigation. The question is what was represented to this court is that he could not have seen it, that he was not following them. Anything that I have here is not an investigation. All I did was listen to the 911 and read the police report. So in that case, if you think that's inappropriate, then fine, you can go ahead with your statement. And then I will proceed to my sentence.
Right. In addition, Judge, you pulled up a map and you said that it's impossible to see, where the accident was without actually being at the scene viewing it. There was no trial. There was no any opportunity for the defense to present you with counter evidence or anything like that, Judge.
Counsel, what do you want to give me? What do you want to give me?
I don't want to give you anything.
What do you want to give me? No, Judge, counsel, if you're going to say I'm being unfair, what do you want to give me?
Judge, I want to tell you that I don't believe you should be considering anything that will occur after that.
What you represented to this court, and I realize you're advocating for your client about him being someplace further from that scene, it's not true. It's his own statements. These are not anything where I went out there and I'm looking at something or I'm doing whatever. It's just placement. He's saying he's at first. I just listened to the tape. I didn't do anything. I didn't go out there and investigate, talk to any witnesses, do anything like that. I did that and looked at a map. That's all I did.
Right, Judge.
So if you want to give me something, counsel, you can come here 2 hours late. Give me what you want to give me.
Judge, I don't believe you should be considering anything after the fact of the initial accident. He's being sentenced for failure to stop at a PD accident. It has nothing to do with what he did afterwards. It's completely inappropriate for the court to be.
What he did afterwards?
After the accident, when he was initially rear-ended, that's what he pled to, failing to stop at that accident. It's not failing to stop at the accident that the girls were involved in. It's failure to stop at the accident where he was rear-ended. Ms. Reiser agrees.
If your client, knowing what I'm going to do, wishes to withdraw his plea, I will consider that motion.
Judge, I would also ask that you recuse yourself at this point.
Denied.
Understood. And I can, if you wouldn't mind allowing me to speak with Mr. Torres, my guess is he's going to withdraw his plea.
I'm sorry?
If you wouldn't mind allowing me to speak with Mr. Torres to make sure this is going to happen, but my guess is he will withdraw his plea.
Can we set up a breakout room for Mr. Torres in signing on to Zoom in one of the conference rooms? Mr. Torres, we're going to put you into one of the conference rooms out there. We're going to put that machine into a breakout room and put your counsel into a breakout room so you guys can talk. Court will stand in recess. All right. Is everybody here? Yes, they are. We're back on the record in the Torres matter. Had an opportunity, well, first of all, that counsel had an opportunity to speak with his client. It's been also an opportunity for the court to speak with counsel. They are going to consider a motion to withdraw the plea or the other and alike. The court is going to give the opportunity for them to file the written motion to do so if necessary. I'm not saying that that's what they're going to do, but give that opportunity. So I'm going to adjourn these proceedings for the motion as well as sentencing. I'll set both at the same time to March, my next sentencing, March 13th. I want a special time so that
3 p.m.
All right, March 13th at 3 p.m. for a continuation of the proceedings. I have directed counsel that everybody needs to be in person at that proceeding.
Understood.
All right, bond will continue. Thank you.
All right, thank you, Governor.
Trying to make a record. I don't see the court reporter typing. Okay, so we only take a record in this court when the judge tells you to? The case was called.
No, the case wasn't
Yeah,
called.
for a record, by the
You
way.
understand? Because they're older than yours. So that's what happened. So then what
Points
ends
are
up
being made,
happening?
there should be a record, right?
Excuse me, stop interrupting me.
Well, we're not on the record,
Stop interrupting me.
right? I mean, we're not in
Stop
court. if there's no record.
interrupting me.
Sir, here's your.
All right, I'm gonna ask you the same question that I asked everybody else. Has an acknowledgement of discovery been done, because I don't have it in the court file?
I have signed a few of them at this point,
All right, so has there been any new discovery?
not to my knowledge.
All right, so you can make sure that the acknowledgement of discovery, the state actually has it and the court has it, and it's not in the court's file. And Odyssey is doing things on its own. So I'm gonna have y'all come back tomorrow. You're not number one on the docket.
Okay.
There are a couple of cases that are ahead of you, so those cases may end up going for 4 years. We'll just see where we are, okay?
That's correct. Respectfully, Your Honor, Mr. Rios always appears, always waits all day. This is impacting his employment. We would ask that if we're not likely to be called tomorrow, that we be released. Additionally, I have experts for this trial that we have attempted to bring in, but we never know, and because the case is older now, when we should bring those experts in. So I'm gonna have to approach the court and request additional funds for those experts if we're reset. So I would ask the court either to give us some preference tomorrow for trial, or if we can't do that, to release Mr. Rios so that he can go to work.
All right, be here exactly at 9:30, okay?
Okay, yes.
All right, I'll supposed to be here exactly at 9:30.
You understand? Now, Your Honor, respectfully, every time we come to court, we lose an entire day of work ourselves too. This is not typical of most of the courts in this county.
Oh, yeah, it is very typical.
It's not.
Yes, it is.
You can say that, Judge, but I practice on
And
the
say that,
courts.
and it very is typical, because every attorney that's here has a case that's set for jury trial. And this is what ends up happening. What ends up happening is I will allow people to go to civil cases to be out of county, and then their client is sitting here waiting for them. And for some reason, that's the court's fault. That's not the court's fault when attorneys are not showing up at 9 or whatever, and then they stroll in at 9:30 or 9:45. So what I'm telling you all, 9:30, see y'all at 9:30. Thank you. Coordinator will give you a reset form.
Understood. Your
All
Honor,
right,
I'm
thank
trying to make
you.
a record. I don't see the court reporter typing.
What?
Okay, so we only take a record in this court when the judge tells you to? The case was called.
No, the case wasn't called. When I call the case, I call it by the style of the case.
Okay.
All right? All right, so I'll see y'all at 9:30.
Judge, I have to ask you, is this a tactic on the court's part to attempt to wear out the defendant so they can't access their right to trial?
Oh. I find that very inappropriate to say when there is no proof and people are just throwing things out. Now, what I can tell you, and I'm sure your client is aware, sometimes when we end up coming to court, we come to court because there are discovery issues. Sometimes when you're in court, you are in court because your attorney is late. And when I say late, I mean that when a case is scheduled in this court and it's scheduled for 9 a.m. and attorneys go to different courts because they want to go to different courts first, it is not the court's fault that you're sitting here for 12 o'clock or 1:30 or coming back over break. Number one, I have a lunch break. And there was a point in time where I would not take a lunch break. And the reason why I wouldn't take a lunch break is because I said, you know what? I've been a defense attorney. And when I was a defense attorney, what I would always do, I'm like, I have to be in like 5 courts. It would be nice if they could stagger their docket. And so sometimes I would be here, we wouldn't have a lunch break, and I would be here till 3 o'clock. And then you know what I discovered? When I would say that I'm going to be here till 3 o'clock, I'm working through lunch, other attorneys, you know what they would end up doing? Then they wouldn't show up in the morning. They would just show up at 1:30 or whatever, because they're like, oh, the judge is going to stay there. So I stopped doing that because I need a lunch break. And that's what happens.
So then my other question, I guess, is if you're not doing this to cause the hardship, it obviously causes all of the attorneys and the defendants. Are you doing this for the YouTube? Because we don't have a record, right? Except for the YouTube.
Yes, here's the thing. You're to be back tomorrow at 9:30. You
Yes.
understand?
Yes.
All right, thank you so much. And once you sign the reset form, you'll be here tomorrow. If somebody goes before you, somebody goes before you. Your counsel is well aware, or should be well aware, if he's been practicing in Bear County,
For almost
that
20
there
years.
are a lot of cases that are on the docket for jury trial. So for example, I had approximately 40 cases down for jury trial today. And what ends up happening, sometimes people who are in custody take precedent because their cases are older
I'm
than
asking
yours.
for a record, by the way.
You understand? Because they're older than yours. So that's what happens. So then what
Complaints
ends
are
up
being made,
happening.
there should be a record, right?
Excuse me, stop interrupting me.
Well, we're not on the
Stop
record,
interrupting me.
right? I mean, we're not in
Stop
court. if there's no record.
interrupting me.
Sir, here's your reset form at 9:30.
So what ends up happening, sir, is that people who are in custody, sometimes their cases take precedent. And the reason why it takes precedent is because their cases are older and because the jail is overcrowded. Now, as you may or may not be aware, I call the docket all the time at 9 a.m. And sometimes when I call the docket at 9 a.m., defense attorneys are not here. Your attorney knows when he has not been here at 9 a.m. and then you have to wait. And you
Judge,
need
you're
to
aware
be
that every
here.
court starts at 9.
And you need to
I
be
have other
here.
cases.
And you need to be here at 9. So when your attorney is somewhere at another court, you know what ends up happening? Your attorney has made the choice to have you sit here and go to another court before
Well,
coming
that's not
here.
exactly true,
You
because all of
understand?
those courts got
All right,
business
good
in
luck to
conflict.
you.
All
Thank
of us
you.
got
Thank you,
recalled
sir.
today,
Thank you,
right,
sir.
Judge? So, I mean, what did we accomplish?
Have a nice
today?
afternoon, sir.
I mean, that's the reason I don't come to your court at 9, because I know in another court,
Sir,
something's
here's your
gonna actually occur.
Sir.
And they're courts of exactly the same
Sir.
jurisdiction.
All right, this way, sir.
Yes. All right, thank you.
23.
Okay, you
This
done?
case is from May 3rd,
I'll let you
23.
go. What? I have the great pleasure of having beside me one of our newest elected judges, Judge-elect Corrine Moore. She will be sitting with me today until she can't stand it anymore, and then she's taken off. All right, so welcome, Judge Moore. Mr. Ganasser, can you start us off?
Good morning, Your Honor. My name is Ganasser, Senior Assistant Prosecuting Attorney on behalf of the people. Conflict between this honorable court and the Office of the Public Defender. Prosecutor's Office does not believe a conflict exists. When present, we waive that qualification. My office, the Office of the Public Defender, before this honorable court.
Thank you, sir.
Ron Brown, Deputy Chief Public Defender. We likewise do not believe that a conflict exists in this honorable court hearing these. If a conflict were to arise, we would waive such conflict so that this honorable court could hear these matters.
Court, for its part, also does not believe that a conflict exists either in Michigan court rules or the cases decided thereunder. To the extent a conflict does exist, given the waivers, the court will consent to hear the matters. Court does call the case of the People's State of Michigan versus Alejandro Montano.
Image Ganatra for the people. Ms. Cratcher's case.
This is the motion. Hamoud withdrawn? Why is she doing that? Let's see.
Good morning, Your Honor. Marcia Cratcher on behalf of Mr. Montano.
What are you going to do if I deny Ms. Hamoud's motion?
I'll be in big trouble.
Oh, okay. All right. I'll grant her motion to withdraw. Go ahead, Kevin.
Good morning, Your Honor. Marcia Cratcher on Mr. Montano. We'll be seeking an adjournment in this matter. He's in federal custody, I believe, at the moment.
All right. Mr. Montano, can you state your name, please, sir?
Yeah, my name's Alejandro Montano.
Thank you, sir. All right. You understand that your prior counsel is withdrawing and you have new counsel. You understand that, sir?
Honestly, I don't even know what's going on.
If I may, Your Honor?
Only if you're going to clarify it.
I am.
All right, go ahead.
Okay. Your Honor, I was just appointed on this case, I believe, yesterday. And therefore, Mr. Montano is in federal detention. And I have sent a request to set up a meeting with him. I believe you're in Hazleton. Is that in Minnesota, sir?
No, that's in West Virginia.
West Virginia. Okay.
Close.
It's been open
maybe
a year
So-
and something. I don't know what's going on with this. I don't know why y'all keep pushing
So,
it.
sir-
I don't know what y'all got going on.
Okay, hold on a moment, sir.
So, Mr. Montano, I will contact the facility that you're in and make an appointment to come and not see you, but at least have phone contact with you, and I can explain that, sir.
See, that's what the last attorney said a month and a half ago.
I can't speak for the last attorney. I can only speak with what I'm going to do. I actually
I'm
was
saying
in
though,
sort-
why would you come and try to talk to me the day before court or a day before court? You need to talk to me like as soon as possible, not whenever you
Okay,
feel
Mr.
like that, y'all. I don't know what y'all got going on.
Okay, Mr. Montano. So I don't know anything about them trying to talk to you. I'm going to give enough time that they'll be able to try to contact you and to be able to talk to you before we get to the next hearing. The
Look,
other
the thing
thing
is, I've been in custody
Sir?
since May 3rd.
I know.
23.
Okay, you
This
done?
case
or-
is from
or
May
you
3rd,
wanna- I'll let you
23.
go. What? Okay, so here's what I'm gonna do. What is 6 weeks out?
January 9th.
All right. What I'm gonna do, sir, is I'm gonna adjourn your probable cause to January 9th, 2025, 9 a.m. Ms. Crater will be in touch with you, and hopefully we can move this case along. All right? Thank you.
Thank you, Your Honor.
This shit is crazy, man.
Gotta mute that, because we got exactly one case done. All right, what?
Good morning, Your Honor. Michael Bavana on behalf of Jillian Carey, present to my right.
Your name, ma'am?
Jillian Carey.
All right. What are we doing on this?
Your Honor, we're going to be setting this for a preliminary examination.
I think we were looking and speaking with Mr. We're still hopeful that there may be an additional report from Detective Parvez, but we're fine with setting this if we could set this into January if possible.
You would agree with that, counsel?
Yes, Your Honor, the weeks of January 20th particularly.
Well, you don't get to pick a week.
Or the 13th.
And all discovery is complete, is that correct, counsel?
Other than perhaps that report, yes.
With the exception of the materials that I requested and was denied, yes.
I don't know what that means.
Your Honor, you denied a motion to compel discovery last time. That is the material I'm talking about that I've not received and the court has not examined. So that will be the discovery that I'm talking about. But I'll pursue that at a different level. Your Honor has already denied my motion, so.
I still don't know what that means. Do you have all of the discovery, counsel?
I have all the discovery that they've given me, yes.
And if I denied your motion, that would mean that would be something that you're not entitled.
That's the court's position. I don't agree with the court's position, and so I can't answer that question that I've gotten all the discovery. I don't.
All right, then I'm not setting it for exam until we're sure that discovery is complete. That's how we work here, counsel. So you guys figure it out. Is, from the people's perspective, has discovery been completed other than the one thing you've indicated?
All right, well, since we were last here in court, Detective Parvez did offer what I would call a supplemental report that has been tendered via email about 2 weeks ago. I also discovered there had been some body cams that hadn't been properly notified, like notice had been sent to my office. Those have also been tendered. So as far as from what is in possession of the people, everything has been turned over. The only remaining discovery that may exist that I'm aware of would be this additional supplemental report by the detective, but that investigation is ongoing.
So I'm going to try this again, counsel. You have all of that. You may disagree with this court's decision, and I could care less, quite frankly. If you want to appeal it, appeal it. The question is, in terms of what should be supplied to you, do you have everything?
I have everything that was described by the prosecutor, Your Honor. So yes.
The people would have their witnesses available January 21st, 2025.
I don't see any reason why not.
Preliminary examination in person, January 21st, is it? Yeah. 2025, 9 a.m. That's before me. And counsel, if you want to keep playing these wordsmith games, I'll go toe to toe.
Your Honor.
Keep trying it, Mr. Vincent. You're going to run into trouble with me real fast. I don't think you want to do that right now. I am just.
Your Honor, you know I did not.
Remember when you were a teenager and your mom or dad would say, "I'm not mad, I'm just disappointed." Do you remember how awful that felt? Can you imagine that same thing coming from our dearly beloved Judge Cedric Simpson? Well, that's exactly what happened with this one lawyer. And Judge Simpson is super upset about it.
The people had filed an emergency bond violation where we asked the court to revoke bond and issue an immediate warrant report to do so. I checked XGL, he's not in custody. I don't see him present. I have no idea where he is.
All right.
He's here, Your Honor.
Is he here? Where is he? Where? You need to come up. I'll call your case. Court calls the case of People versus Cameron Carter.
Morning, Your Honor. John Vincent on behalf of the defendant who stands to my right.
All right.
Say your name. Come on, Carter.
All right. We're going to deal with the bond hearing first and then decide if we're going to go with this case.
Okay. The people issued, sent in that motion because I was going to the victim myself. There was 3 police reports made, 1 made to Romulus Police Department and 2 made to the Wayne County Sheriff's Office. I'm still awaiting the police reports from the Wayne County Sheriff's Office, but I received the Romulus Police report and attached it to my emergency motion. There was text and things that were said by the defendant, threatening the life of the victim. When I spoke to her on the phone, she said she was extremely concerned for her safety, and I shared those concerns, which is why I filed a motion. I'm not sure why Mr. Carter has not turned himself in this warrant and I would ask that the bond to be set at a very high rate, determined by the court and or to remain revoked. These are 3 different violations of bond. He also has a he has the no contact, he has the no go to that we have in this case, and so I don't understand what the reason to reach out for any reason.
Mr. Vince.
Well, Your Honor, is the witness here? Because that is all, I mean, all the allegations are based on her words. There's been no police contact, no video, no third-party witness, no DNA, no fingerprints, no police contact with my defendant here.
So he wants a hearing on this bond violation?
None of these phone numbers connect to his account. There, he absolutely denies the allegations in here. There is no physical evidence, and if there is not a witness here, Your Honor, then both the underlying case should be dismissed and this alleged.
I'm not even talking about the underlying case. So just deal with what I told you to deal with.
All right, well.
Does he want a hearing on the bond violation?
Absolutely, Your Honor.
When are you going to have the other report?
I'm not sure, but I can check on that today. I'm also waiting for the actual screenshots of the text messages that are written in the Romulus Police report. And if he's saying that that's not his phone number, I can also get a search warrant as to that effect.
In that police report, there are 6 phone numbers listed. The police report indicates that none of those numbers are Mr. Carter's. If there are screenshots, I have not received those screenshots. It's the first time I'm hearing that there are 2 other potential police reports out there. However, this police report says that 2 officers showed up. I don't know how a Wayne County Sheriff's Department police report would be any different than this, as far as I can see, there were no Wayne County sheriffs on the scene of this alleged incident. There's just simply no physical evidence. There's no third-party evidence. And frankly, if you read through the report.
I did. Before I revoked your client's bond.
Yeah, okay, well, I would hope you did. When you start to read through it, the allegations in there, either it's a lie or he's the luckiest guy on the planet, because I would think that the Romulus PD would be able to get over there in the length of time that all of this stuff is alleged to have happened and find a purple Taurus. She says at 1 p.m. He began to call her, and it somehow got into an apartment, beat on the door of the apartment, left the apartment, started yelling through the window, then generated somehow, all while outside, 6 other phone calls from 6 different numbers, none of which line up to the defendant. If she's not here, Your Honor, then I think that that is a very, very strong indication that this is not factual. The other thing in this, Your Honor, this person alleges that he stole a gun from her in Pittsfield Township. Well, you know, if that's the case, then shouldn't this have been a little higher priority? I think prosecution knows that this is not accurate. There's just simply, there's nothing before the court today to indicate that he is guilty of what they're saying he's guilty of. If she's not here, she should have been here. There's no Romulus police officers here, not that they saw anything anyway. There's no third party in the police report that says witnesses, none. Wait a minute, he's broke into this apartment complex, banging on the door, goes outside, supposedly shouting the N-word. Don't you think somebody would have witnessed that, especially at 2 p.m.? Oh, you know, without a witness, without some shred of physical evidence, there's nothing. This is just the allegations of someone who did not bother, apparently, to show up to court, both for this and presumably for the underlying charge.
So far, a pretty reasonable argument, you might say. Well, Miss Kirby doesn't think so, and it seems from the judge's reaction that he doesn't think so either. It's about to go down, basically.
First thing, this defendant is on bond awaiting this final settlement conference where he's charged with domestic violence. He's also on bond awaiting pretrial where he's charged with child abuse forward. He's also on bond awaiting a probable cause conference where he's charged with resisting and obstructing a police officer and fleeing third degree. Mr. Vincent claims that he knew nothing about screenshots. Well, I just said on the record I don't have them. I'm awaiting them. But they are in the Romulus police report. They say that they do have screenshots, so maybe he didn't read that report. Also,
Your Honor, I don't have screenshots. You will not interrupt, ever. I let you go on and on. I told you what I'm trying to focus on here. Keep trying it, Mr. Vincent. You're going to run into trouble with me real fast. Ms. Kirby, you may continue.
Thank you. I also explained in my motion that the Romulus police report is different than the two other contacts that this victim had with the sheriff's department. I've included those police numbers. Those are also in the motion. So I'm not sure what he means on, I have no idea why the sheriff's department and Romulus were here. No, it's completely different. And I don't have the accusations in those. I'm awaiting to get those, given that they're not in our county, and I followed the process to get those. Also, this is, if we're having a bond violation hearing, I would just remind the defense counsel that it's not beyond a reasonable doubt for a bond violation. So I would ask the court to take what it has in front of it, including the Romulus PD report, and either adjourn so I can get the other police reports, and so I can get the actual screenshots and possibly a search warrant for this. And I would ask for the defendant's bond to be revoked and he to be remanded. Given the seriousness of this case and the seriousness of his other two cases, I do believe he's not only a threat to the victim, but to the safety of the community and also children. He seems to find it funny as his defense attorney speaks, which also tells me that he does not take this as serious at all, which also concerns me. As for the complaining witness not being present, I did not know that he was going to be here. I thought he was still out since he had not turned himself in, and his attorney was well aware that he had a warrant out, no bond. So she is not present. Last time I spoke to her, she was in fear for her life. She said she would continue to answer the phone, but she has been placed in a different place that I know of the location that she does not want me to share out loud. I have no problem sharing that with the court, but she is not present. And regardless if she was present or not, I can still proceed based on forfeiture by wrongdoing with the interference that the defendant has committed himself through these other police reports. And I was going to ask for time to get those anyway so that I could present those at trial. So regardless if she is here or not, and just for the record, the court rule does not actually say I have to have a witness present. It actually says I have to say if I can proceed or not, which is what I'm doing.
Mic drop.
Thank you.
I don't know how they could possibly proceed when there is not a
That's
snitch.
not your issue. They've made the representation to the court.
Okay, and I'm making a representation to the court that when you read the police report, which you have,
I read it.
then you know that there is only her allegation. At least for what I have in front of me and what you have in front of you. And he is here. He's availed himself to the court every time that I've had anything to do with him.
Why didn't he turn himself in between the time I revoked his bond and today?
Now, this is where we get to the juicy stuff, the meat of this whole argument. It is alleged that this lawyer told his client to not turn himself in and instead turn up to court. That's a big, big problem.
Because you, as an officer of the court, should have instructed your client to do that the court had revoked his bond. So I want an answer to that question.
Yeah, I mean, we were going to be here today.
That's not an answer to my question. Mr. Allen.
According to what the defendant just told his attorney is that he told him to just show up today and not turn himself in.
That's correct, Your Honor. I mean, and that if.
Oh, put me in handcuffs, man. That's a wrong answer.
I'm
way the wrong answer.
I'm sorry, man.
I'll deal with this in a minute because right now I'm furious, Mr. Vincent, that you would represent that client. Defendant's remanded. Take him. Court's gonna stand in recess.
Now, that was the Judge Simpson version of just you wait till your dad gets home. He is pissed. The lawyer just admitted that he told his client not to turn himself in when he knew that there was a warrant out for his arrest. This gets even hairier.
Court calls the case of the people versus Cameron Carter. Recall.
Now, Vincent, on behalf of the defendant. Yeah, there was absolutely a mix-up. And as much as my understanding was that he had spoken to the court and they did not tell him to come in, and I should have come in. Yeah, it's absolutely a mistake on my part.
Well, it's not only a mistake, it's a sanctionable offense. And I think you ought to know that. To willfully tell a client or even to intimate to a client that they should in some way disobey a court.
In no way, shape, or form, Your Honor, did I meant to have that effect happen. My understanding was that he had seen you in person this week and that you come to court from. I would never, and I think you know that about me, I would never have anyone try to knowingly or disobey an order. I would never knowingly disobey any of your bond conditions or orders. He is, I mean, I don't know, Your Honor, this is a horrible mistake and I'll fall on my sword for it, but it is a misunderstanding. It's not any, in no way, shape, or form was I trying to get him to avoid justice, and he certainly is trying to avoid justice on this, Your Honor. I understand that these charges and allegations are serious. I mean, all I can say, Your Honor, is that my understanding was that he had spoken to the court this week and that he was free to come here Friday. We clearly had, at no point did I ever advise Mr. Carter to do anything else other than follow the law. And must have told him that a dozen times, something that every time I've talked to him, do not violate your bond, don't violate your bond, show up Friday. That's when we have a court date. My understanding was that was the understanding. And it is absolutely a snafu on my part, and I beg the court's forgiveness. He has an appointment today at 2 p.m. to see Washington Community College counselor. He's trying to get his CDL so he can take care of his kids. He is working at another job. He's availed himself to court today, Your Honor. If this is bound over to jury selection, he'll be there then too. He understands this is serious, Your Honor. He's just vehement in his innocence, and I perhaps have been overzealous on my part. I meant no disrespect to you, court, to the people.
What I'm going to do in this case, because, I mean, something's got to be decided as to what was told this defendant. That may have to be resolved some other way, but the court will take whatever action it deems necessary, and I won't do that until
June 26th, if I deem it appropriate to do so, because as angry as I am right now, I'm not going to make that decision on that. I will set a bond hearing in person in this case for June 26, 2023 at 9 a.m. All of the paperwork will be sent over, and we can deal with it at that point. In the interim, defendant's bond is revoked. I will adjourn the jury final settlement conference that we were going to have today, as well as the jury selection. Jury final settlement will be my next one, August 11th, 2023 at 9 a.m. Jury selection, August 14th, 2023 at 8:30. Defendant's remanded. I don't think you want to do that right now. I am just.
Your Honor, you know I did not.
Oof. That was ice cold from the judge there. Yeah, it seems like it really hit a nerve with him. Let me know what you think down below though. Do you think that this was intentional or not? Anyway, folks, I really hope you enjoyed this video. If you did, make sure and hit that thumbs up, and we'll catch you in the next one. Slán.
Do you have any evidence?
Your Honor, this is not my case, but I do have the Cash App in question here. That was actually
Judge, this is improper.
I think you gotta wait till your trial.
You know what I'm saying? That's not my client, Mr. McNaughton. But Mr. McNaughton is the one who's in jail. He's 16 years old. He's been there for 3 weeks. I don't know how the DA, the officer, everybody can be so happy.
That's correct, Judge. You did. And Attorney Jerome was present when you indicated that it would be placed on Wednesday's calendar because of the process, the procedure is that there should be a pickup order, and the juvenile will be brought to the sheriff's office.
Everybody's
Can you please?
Everybody's talking at the same time. All right.
And Ms. Freeman thought that it was her position to jump in and interrupt.
You jumped in and interrupted a hearing that you weren't involved in. So there's been a whole lot of interrupting. Would everyone just settle down for a second?
Hold on to your peaches, folks. We're heading down to Georgia. Shout out to Georgia Peach. Hope you're doing well. So anyway, this is a really interesting case that I came across yesterday. This young man down here is being implicated in kind of stealing something. It's really, really hard to figure this one out. And it seems like his lawyer is big mad about it. You're going to see him kind of towards the end of the video, but it's actually a fascinating case. So I'm just going to let it play for you. Let me know down below what you think. I want to know, if you were on a jury right now, would you be convicting this guy based on what you've got, or would you be letting him go? I'm still undecided, so I'll wait to hear what you have to say down below.
Okay, we are back streaming live on YouTube. I'm calling the state of Georgia versus Westland Garcia. Warrant number 2023WA13559. There at the jail, if you're a Westland Garcia, just wave at me to confirm that's you. Okay, Mr. Garcia, can you hear me? Okay, can you wave at me? Just confirm you're Westland Garcia. Okay, thank you, sir. You are charged with armed robbery. Representing the state is Ms. Freeman, and representing Mr. Garcia is Ms. Porter. And Ms. Freeman, you can call your witness.
Thank you, Your Honor. Officer Porter, would you raise your right hand, please? Do you swear and affirm that the testimony about provided in the matter of state of Georgia versus Westland Garcia will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, ma'am.
Thank you. You can lower your hand. Please tell us your name and how you're employed.
I'm going to be Officer Porter, badge number 207. I'm employed with the city of Riverdale by Riverdale PD.
How long have you been with the Riverdale Police Department?
It'll be going on 2 years.
Were you working with the Riverdale Police Department on August 5th of 2023?
Yes, ma'am.
On that particular day, were you dispatched to 558 Shadow Moon Drive in Riverdale, Georgia for a theft or an armed robbery call?
Yes, ma'am.
What exactly is at that location?
It's going to be a residential home, ma'am.
Was this the residence of Eric Bodie or Body?
Yes, ma'am.
Is that the alleged victim in this case?
Yes, ma'am.
When you arrived at Mr. Body's address, what did Mr. Body tell you that happened?
Okay, so I was dispatched to 558 Shadowmore Drive in Riverdale at approximately 1:30 in the afternoon. Once arriving on scene, I spoke with the complainant, Mr. Body. Mr. Body stated that he tried to sell a ATV four-wheeler, blue in color, to the defendant, Mr. Garcia, and another juvenile. At that time, Mr. Body said they agreed to pay him $300 for the said ATV. He said they went to pay the transaction through Cash App, at which time that transaction declined and he looked down at his phone. Mr. Body then stated as he looked back up, Mr. Garcia had a black and silver handgun pointed at him while his co-defendant loaded it into the back of his pickup truck, and they told him not to move and pulled off with his four-wheeler.
Was Mr. Body able to give you a description of the individuals?
Yes, ma'am. So Mr. Body was able to give us a description of both males. He said it was the Hispanic male that was in possession of the firearm pointed at him, while the black male loaded onto the back of the pickup truck. He was also able to give us a description of the pickup truck, which they loaded it into, at which time we were able, myself and Officer Hall, were able to use our devices to get onto the flock camera system and track that vehicle's direction of travel, at which time I was able to get the license plate off the vehicle, get the register's owner's name, which would be Mr. Garcia's father. And I spoke to Mr. Garcia on the phone, who advised that four-wheeler was in his son's possession, and he would bring his son plus the other defendant back to the location with the ATV.
Is that what happened, Officer Porter?
Yes, ma'am.
How long was it before it was returned?
We were able to get him to return in approximately 40 minutes, 30 to 40 minutes.
Were you able to locate the firearm that Mr. Garcia used?
No, ma'am.
Did Mr. Garcia provide any statements about what happened?
Yes, ma'am. In return, Mr. Garcia stated that they came to purchase the four-wheeler, but his story was flipped to where he said Mr. Body pulled out a firearm on them and they just pulled off because they were scared.
Were there any other witnesses there that you
No,
were
ma'am.
able to talk to?
No, ma'am.
Was there any type of video surveillance or footage that you were able to review?
No, ma'am. We did knock on the doors because we seen some of the neighbors had Ring door footage there, but none of the camera angles were pointed at the direction of 558 Shadowmore.
The juvenile who was present, was that Mr. McNaughton?
Yes, ma'am.
Did he provide a statement about what happened?
Yes, ma'am. At that time, he also stated that Mr. Body pulled out a firearm on them, and that's why they pulled off. He also stated that he arranged to make the Cash App payment, and then the payment did not go through, and he was scared that Mr. Body was going to know where he was, so he changed his Cash App name on the app.
When Mr. Garcia provided, I guess, his story about what happened, was he able to explain why he had Mr. Body's ATV?
No, ma'am.
So we're clear, officer, Mr. Body did not give Mr. Garcia or the juvenile permission to take his ATV.
That is correct.
Did all this happen in Clayton County?
Yes, ma'am.
Thank you. I have no further questions.
All right, Ms. Porter.
Thank you, Your Honor. Officer Porter, couple of quick questions. Mr. McNaughton is a juvenile, correct?
Yes, ma'am.
I believe he's 16 years old. Is that right?
Yes, ma'am.
Would you say that he's a relatively small young man?
Yes, ma'am.
Okay.
Oh, Ms. Porter, you're mute.
So,
Okay, good.
the 200 ATV and onto the bed of a truck.
I'm sorry, you cut out for a minute. Can you repeat the question?
I'm sorry. So Mr. Body's story is that Mr. McNaughton, who you agree is a relatively small young man, picked up a ATV and put it onto the bed of a truck by himself.
Yes, ma'am.
Okay. Did you see the ATV?
Yes, ma'am.
Okay. Would it be fair to say that the ATV probably weighs 200-300 pounds?
I can't make that assumption, ma'am.
Okay. Do you know how much an ATV weighs?
No, ma'am.
Have you ever tried to pick up an ATV?
Objection, Judge, it's not relevant.
Your Honor, it's relevant because they're saying that he stole it, and the way that they stole it is that he picked it up by himself and placed it onto the bed of a truck. So I'm trying to determine if a young man, small in stature, could in fact have picked up an ATV off the ground by himself.
Okay.
Not at this stage. No.
I think the officer has testified he doesn't know how much it would weigh. So so you can kind of move on that.
Thank you, Your Honor. You never found a gun on either of the defendants, is that correct?
No, ma'am.
Okay.
Because they had fled the.
Okay. Did you ever ask, after speaking with both of the defendants, whose story appears to have been the same, is that correct?
Yes, ma'am.
And their story is that they did not have a gun, but Mr. Body, in fact, had a gun. Is that correct?
Yes, ma'am.
Did you ever ask Mr. Body if he, in fact, had a firearm?
Yes, ma'am.
And did he have a firearm?
No, he stated he did not, ma'am.
Okay. Did you, in fact, see the declined Cash App transaction?
Yes, ma'am.
Okay, so it is clear that the kids did, in fact, attempt to Cash App Mr. Body. Is that correct?
Yes, ma'am.
Okay. Did you ever ask Mr. Body if his Cash App was flagged?
No, ma'am.
Okay.
Yeah. So from my experience of the decline transaction that went through, it's common for people to send a transaction but leave their phone on airplane mode so the payment does not go through.
Okay. But you don't know that that's what happened in this case, correct?
No, ma'am.
Okay. And Mr. Body says that he contacted Mr. Garcia's father. Is that correct?
No, ma'am.
You contacted Mr. Garcia's father?
Yes, ma'am.
Okay. And you asked Mr. Garcia to come back. Is that correct?
Yes, ma'am.
And they did, in fact, come back. Is that correct?
Yes, ma'am.
Okay. So they weren't
after Mr. Garcia had to make his son come back.
Were you there during that conversation?
No, ma'am. I was on the phone with him.
Okay. So Mr. Garcia brought his son back. Is that correct?
Yes, ma'am.
Okay. And you said he had to make his son come back. Is that right?
Yes, ma'am.
Is it possible his son was scared because Mr. Body had pulled a gun on
That
him?
would object. That's speculation.
Sustained.
Did Mr. Body ever say that he followed the boys at all after they left?
Yes, ma'am. He said when they pulled off in the truck after they got halfway down the block, he ran after the truck to see in which direction they were traveling.
Okay. And then what did he do after that?
He came back to his residence and called 911.
Okay. So it's his story that after these young men pulled a gun on him, he then ran after their truck.
Yes, ma'am.
Okay. Was there ever a conversation about the boys just paying Mr. Body once the father brought him back?
No, ma'am.
Okay. Did Mr. Garcia ever indicate that it was his intention to steal this ATV?
No, ma'am.
Okay, did he indicate that it was his intention to purchase the ATV?
Yes, ma'am.
And he told you, correct me if I'm wrong, that the Cash App failed and then Mr. Body put a gun on them, so they left. Is that correct?
Yes, ma'am.
Okay. That's all I have, Your Honor.
Okay, Ms. Freeman, any follow-ups?
No, Your Honor, the state rests.
Okay, thank you.
Your
Ms.
Honor-
Porter, do you have any evidence
Your
to
Honor,
present?
this is not my case, but I do have the Cash App in question here. That was actually
Judge,
denied.
this is improper.
I think you gotta wait till your trial.
Thank you,
Your Honor,
Judge.
can I ask?
I said, hang on, everybody, hang on. So, Mr. Jerome, let me address this real quick. I think you're essentially sitting in the gallery right now, so I don't think it's proper for you to come in. I think you're gonna have to wait till your rescheduled date for your client.
Judge,
So-
can I have a brief moment? I believe Mr. Jerome may have some evidence that's pertinent to my case. If I can have just a quick second, I can grab it from him and be prepared to introduce the evidence myself.
Judge, I'm going to object to that. I asked that we reset both defendants on the same day. Attorney Porter was the one who objected to that and wanted to proceed today. And because Attorney Jerome improperly inserted himself into this hearing, now Attorney Porter wants a moment to talk to Attorney Jerome. I object to all of that because Attorney Porter had the opportunity to wait and do this hearing at a later date, and she chose not to.
Your Honor, I understand that it's improper for Attorney Jerome to insert himself into the case.
Well,
I don't
so
think it's
hold
improper.
on. Let's start there. So, Attorney Jerome. Okay, turn your camera off. All right, now, Ms. Porter, go ahead.
I don't believe it's improper for the defense to ask for a brief moment to gather some evidence.
How are you going to talk to him?
I'm going to call him very briefly.
All right, we'll take 3 minutes, okay?
Thank you, Your Honor.
Okay.
And judges, my objection is noted for the record.
Yes, ma'am.
Thank you.
All right, everybody back.
Yes, Your Honor.
Ms. Freeman, hang on just a second. I don't think Ms. Freeman's back yet. Okay, Ms. Freeman's back. Okay, Ms. Porter.
Yes, I'm here. I'm sorry.
Your Honor, I'd actually like to ask Mr. Garcia's father, Alexis Garcia, to log into the Zoom. I believe he's watching it from YouTube right now.
Judge, that is going to be a problem. And my objection is if Attorney Porter has just admitted that the witness has been watching the hearing via YouTube, that certainly goes against any kind of separation of witnesses. She did not announce any witnesses in the beginning. When Attorney Jerome had announced his witnesses, they were placed in the waiting room. But she has just admitted that this witness has been watching it via YouTube.
Okay. I asked at the beginning whether you were going to be presenting witnesses for that reason. And so I'm not going to allow him to testify today. Do you have any witnesses who, I asked you earlier if you're going to have any witnesses and you didn't have any at the time. So Ms. Porter, I think we're ready for closing arguments at this point.
Yes, Your Honor.
Okay. Ms. Freeman, closing.
The state waives opening.
All right, Ms. Porter.
Your Honor, this is not a situation of an armed robbery. This is a situation where two young men went to purchase a ATV from Mr. Body. They sent a Cash App. The Cash App actually declined because Mr. Body's Cash App was
I'm going
flagged.
to object. Attorney Porter is trying to introduce something into her closing argument that was not testified to.
Your Honor, additionally, I withdraw that portion, Your Honor.
I didn't catch actually what the statement was, the end, so it really doesn't matter anyway. So go ahead, Ms. Porter.
So the Cash App was bounced back. The state is attempting to claim that a small statured young man picked up a four-wheel ATV on his own, high enough to place it onto the bed of a truck. I find that to be incredulous and hard to believe. What actually happened, Your Honor, based off of what the officer testified, what both of the young men testified, and this is a situation where you have two young men saying the exact same thing versus one person who's saying something else. These young men went to purchase an ATV from Mr. Body. They sent him a Cash App. They both together loaded the ATV onto the back of the truck while Mr. Body was there. The Cash App then declined. Mr. Body then pulled a weapon.
Judge, I'm going to object again. Attorney Porter, in her closing argument, is trying to introduce statements that weren't testified to.
Ms. Freeman, I think everything she just said was exactly what the detective said that the defendants said. So I don't see any problem with what she just said. I'd like to let her finish closing.
Okay.
The young men then left. At some point in time, Mr. Body followed them and pulled a weapon on them, and they fled from the scene because they were afraid. It's my understanding, based off of what the officer said, and based off of just simple 1+1, that once the Cash App failed, Mr. Body pulled a gun on the kids left. When the officers called and asked for them to come back, they came back. Mr. Body got his ATV back. There was no conversation about whether or not they could just make the additional payment. At most, Your Honor, at the very most, this is a theft by taking situation. This is not an armed robbery situation. There was no gun found. Neither of the boys testified, or the officer testified that neither of the boys said that they had a gun. Both of the young men said that Mr. Body is actually the person who had a gun. And I don't believe that it's disputed that there was, in fact, a Cash App sent. I don't believe it's disputed that the young men actually left. Whether or not who had the gun, I think maybe the only question here. But I think that in a situation where you have two people saying, we did not have a gun, the other person did, the weight of evidence, I believe, Your Honor, should tend to fall towards the two people as opposed to this one victim who is attempting to make this be an entirely larger situation. And to be totally honest, the victim at this point is not out of anything because they brought it back. All the officer had to do was call and ask, and they came back to the scene. I think that the charges should be dismissed in its entirety. If the court doesn't find that the charges should be dismissed, I would ask the court to reduce the charges to a theft by taking, because I do understand that the boys did leave and the Cash App did in fact bounce back. But I don't believe an armed robbery is appropriate here. There honestly is no evidence that there was ever a weapon held by this defendant. So I would ask the court to dismiss it in its entirety, and if not, to reduce to a theft by taking.
Okay, Ms. Freeman.
Thank you, Judge. We're asking that the charge of armed robbery is bound over to Superior Court. We heard the testimony from Officer Porter when he spoke to the victim in this case, Mr. Body. He indicated that Mr. Garcia held the gun on him while the other individual grabbed the ATV. Neither of the individuals were able to explain if Mr. Body was the one who pointed the gun, how in the world did they come to take his ATV? They didn't have his permission to take it. Officer Porter contacted the defendant's father, Mr. Garcia, and after speaking with him, he stated that he would make his son bring the ATV back. Yes, it was returned, but that does not negate the fact that there was an armed robbery. There was a gun used. These two individuals took the ATV. And we're asking that the one charge of armed robbery is bound over to Superior Court.
Okay, thank you. Based on the evidence and testimony presented, I do find probable cause to bind over the charge of armed robbery to Superior Court. I will issue that order today. So thank you, everyone, and everyone here for the Garcia hearing can be excused.
Your Honor, are you able to hear us on a bond issue?
No.
It has to be filed in Superior Court.
Thank you.
Okay, thanks.
Thank you. And Judge, and I guess may Officer Porter be excused until next Wednesday, the 6th?
Yes. Yes, thank you,
All right.
officer.
Your Honor.
Thank you.
Your Honor, excuse me, before you release Officer Porter, I did not hear the court essentially, I don't know how come the court would continue my case without my presence. I was actually on the phone with the RYDC, and they said that they do have a setup for Zoom. They usually use it for first appearance, but they can use it for this preliminary hearing. So we are going to have my client's preliminary hearing. He's a 16-year-old kid that didn't do anything wrong. And
I postponed this in our conversation earlier.
That's correct, Judge. You did. And Attorney Jerome was present when you indicated that it would be placed on Wednesday's calendar because of the process, the procedure is that there should be a pickup order. And the juvenile will be brought to the sheriff's office.
Please,
everybody's
can you please?
Everybody's talking at the same time. All right.
Speaking, and Ms. Freeman thought that it was her position to jump in and then interrupt.
You jumped in and interrupted a hearing that you weren't involved in. So there's been a whole lot of interrupting. Would everyone just settle down for a second? Mr. Jerome, this was addressed earlier. You were on. We talked about how are we going to handle this because there was no production order. That is the process here. And we said, we're going to postpone your hearing. We then just moved on to this hearing that we just held and decided we're going to go ahead and move forward with that because that attorney had a leave of absence for the date next week that when we rescheduled yours. You've now jumped back in and you've told me, well, I wasn't there. You were there when we talked about this. So I'm not quite understanding what's going on, but I'm going to let you speak. Go ahead.
All right. I understand that the officer went, the last that I heard, the officer was checking to see if there was a production order put in, which I had already known that there was not. I actually was at the YDC yesterday and I spoke to them and everything else. And had I known, I would have handled this yesterday. But nonetheless, Your Honor, this is not the issue of Mr. McNaughton. You know what I mean? He's a 16-year-old kid. He's, you know what I'm saying? Essentially, he turned himself in. He came back to the scene. He called 911. You know what I'm saying? He did all this. This is not somebody that was running or acting like any kind of criminal at all. The person that is the criminal, the person who actually has cases here in Clinton County is Mr. Body. Mr. Body is the one who makes false police reports. Mr. Body is the one who has trespassing charges in Clinton County.
There's really
a theft by taking. You know what I'm saying? That's not my client, Mr. McNaughton. But Mr. McNaughton is the one who's in jail. He's 16 years old. He's been there for 3 weeks. I don't know how the DA, the officer, everybody can be so happy just letting this kid sit in jail, miss school and all this, and he didn't do anything wrong. Did they even look into Mr. Body and what kind of person he is?
Is Sergeant Barton in the front?
All right, you ready for me?
Officer Porter, make sure you stay muted, please. Stay muted, Officer Porter.
Again, that case is reset. Your client's case is reset. I believe it's September the 6th. I think it's a week from now. These are all these issues that you are bringing up are issues you can bring up in that hearing. But for today's business, it's reset. That takes care of it. And you can be excused, Mr. Jerome.
All right. Thank you, Your Honor.
Okay. Thanks.
Well, there we have it, lads and lassies. I just watched it again as I was editing this together, and I'm still none the wiser as to what exactly happened. What I do know is if you are looking for a lawyer to fight your corner, that guy is the guy to do it. Now, if you like watching videos with angry lawyers, stay tuned to the end of this video. You'll see it pop up on the screen here. There's another one. It's absolutely awesome. I hope you enjoyed. Thank you so much for joining me, and we'll catch you in the next one. Sláinte.